In 1995, the Pepsi Cola Company launched a promotion called Pepsi Stuff. Consumers earned points by buying soft drinks, which they could redeem for branded merchandise like sunglasses and leather jackets. To advertise the catalog, Pepsi ran a television commercial with an escalating narrative. It culminated in a teenager bypassing the morning school bus to land a military attack jet in his high school yard. As the teenager steps out of the cockpit, an on-screen caption priced the aircraft at 7 million Pepsi Points. The aircraft depicted was a United States Marine Corps AV-8 Harrier, an active-duty military vehicle capable of vertical takeoff and landing. In the mid-1990s, a Harrier Jet had a unit cost of roughly $33 million. Millions of viewers recognized the advertisement as an obvious corporate joke. John D.R. Leonard, a 21-year-old business student, decided not to laugh. Leonard bypassed the commercial's fantasy and read the fine print of the actual Pepsi Stuff catalog. The rules contained a mechanical loophole for consumers who lacked the required points for an item. They could purchase points directly from Pepsi for 10 cents each. Leonard did the math. At 10 cents a point, 7 million points cost exactly $700,000. He saw an opportunity to acquire a $33 million military aircraft at a massive discount. He secured backing from investors, filled out a catalog order form, and mailed 15 original Pepsi Points along with a check for exactly $700,008.50, covering the remaining points plus shipping and handling. Pepsi promptly rejected the check and returned it. Leonard sued, demanding specific performance, a court order compelling the company to deliver the jet. The lawsuit created a unique legal vacuum. A corporation claimed its broadcast was an obvious joke, but a citizen had technically fulfilled the stated mechanical requirements of the promotion. The dispute arrived at the federal courthouse in Manhattan in 1999, landing on the desk of District Judge Kimba Wood. Leonard faced an immediate doctrinal hurdle. Under contract law, advertisements are generally not legally binding offers. They are considered invitations to deal, requests for consumers to make an offer that the merchant can then accept or reject. There is a narrow historical exception, rooted in the canonical Lefkowitz case, involving a Minnesota fur stole advertisement. An ad can be binding if its terms are exceptionally clear, definite, and explicit, leaving nothing open for negotiation. To apply this rule, the court had to distinguish what the television commercial showed on screen from what the Pepsi promotion actually offered in writing. The factual reality destroyed Leonard's first argument. The Harrier Jet was never listed in the official Pepsi Stuff catalog, which served as the operative, definitive document for the promotion's redemption mechanics. The commercial itself was legally incapable of being a formal offer. However, the court still had to address Leonard's persistent claim that he subjectively believed the broadcast was a sincere promise. Contract law relies on the objective theory of contracts. This doctrine explicitly separates a plaintiff's personal, subjective belief from objective legal reality. The system uses a reasonable person standard. The law completely ignores what Leonard claimed he felt or believed and asks only how an average objective observer would interpret the commercial. To apply this standard to the lawsuit, Judge Wood had to perform a legal autopsy on a joke, noting in her opinion that she must explain why the commercial is funny. She systematically documented the specific factors proving the commercial's absurdity. A teenager using a military aircraft to inject drama into a morning commute to high school is an exaggerated adolescent fantasy, categorized by the court as obvious, zany humor. Furthermore, accumulating 7 million points would require drinking roughly 190 Pepsis a day for a century. Acquiring the points for $700,000 to demand a $33 million jet is a deal too good to be true, and objectively absurd to any reasonable viewer. Under the objective theory, a corporate joke cannot become a binding contract merely through willful literalism. The court noted one final fatal procedural roadblock, the Statute of Frauds. Even if the commercial had somehow survived the objective theory test, the law requires contracts for the sale of expensive goods to be cemented in a signed writing. The Pepsi Cola Company never drafted, let alone signed, any document agreeing to transfer Marine Corps military hardware to a college student in Seattle. The American legal system possesses multiple interlocking procedural safeguards, from the definition of an offer to the Statute of Frauds, to prevent absurdity from becoming enforceable law. The Second Circuit Court of Appeals issued a per curiam affirmance, endorsing Judge Wood's deadpan logic. Pepsi won a total legal victory, yet their real-world reaction was an immediate concession to the hazards of literalism. They quietly re-edited the commercial. The price of the jet was raised to 700 million points, and the company added an explicit "just kidding" disclaimer to the screen. The legacy of Leonard versus Pepsico is a permanent fixture in contract law textbooks. The objective theory demands mutual, reasonable understanding, proving that while the law will protect a corporate joke, corporations prefer not to test that protection twice.